Okay, here we
You're
go.
on, buddy.
So I'm Bob Carr. I'm the founder of Link Silicon Valley, where we track a lot of data from all around Northern California. I've known Roger for 30 years. He's the guy I always wanted to meet, and we've become very good friends. And I thought at one point, I said, Roger, why don't we do something on Link SV together where we talk about legal issues? So we said we envisioned a clock with 12 hours on it. Each hour represents a different topic in the legal section. And so we did that. I think we're on our fourth session right now. And is contracts important? I'm an active angel investor. I could tell you if one of my portfolio companies gets a big contract, I'm all excited. I sure as hell wouldn't be very excited later on to find out there are problems. And that's why I'm here today, Roger. Are there problems in contracts? So I'm gonna listen up.
Oh, okay. Well, thank you, Bob. I'm Roger Royce. I'm a partner with Haynes Boone in downtown Palo Alto. Haynes Boone is an Am Law 100 law firm with about 700 lawyers, and I do emerging growth and venture capital. That's all I do. That's what I focus on. And now comes the most exciting part of the presentation. I'm about to share a screen. All right, hold on here. Okay, you should now be seeing. Don, are we good?
Yep, I can see the screen. Now, are you in display mode?
Yes.
Okay.
All right, let's go. So we're going to talk about contracts today. And this is and keep in mind, it's contracts for startups. I mean, we don't have enough time in the world to talk about all the possible contracts someone could enter into. So I'm going to kind of focus on what kind of contract issues you're going to run into as a startup company. By the way, is my audio okay?
Yeah, excellent.
Using a weaker mic.
Yep, clear.
Okay, that didn't work. Let's try this. There we go. So I'm going to cover at a high level just some basic concepts, first of all, because I think it's important just to kind of understand a little bit about contract law generally. And a lot of these other things I talk about will make a lot more sense once you understand what this big umbrella of overriding rules are. We'll go into very specific commercial contracts, a little bit about intercompany agreements, and then talk about some specific types of contracts that are sometimes their own little world, like real estate leases, bank agreements, and then some of the regulatory environment. So let's just start with the key elements that every contract really has to have. And this is something we all learned in law school and didn't really understand the significance of it, I suppose, until we got out into the real world. And I'm going to explain why these high-level concepts are important, how they play out in the real world. So first of all, to have a contract, you have to have a meeting of the minds. That means there's an offer and then there's an acceptance. That part might sound simple, but I'm going to talk about how we get in trouble over that. Secondly, this concept of consideration, which a lot of people equate with value, but that's not quite right. What it really means is the bargained for exchange. And again, people forget about this. Even lawyers forget about this, I notice sometimes, but it is important. And in order to have an enforceable agreement, and by enforceable, I mean that's something that a court will enforce, because that's what a contract is, right? It is a promise that a court will enforce, as opposed to a promise that a court will not enforce. And consideration is one of the fundamental components of that. We need parties that are competent to contract. We want to be able to reflect, and the court has to be able to discern what the intent of the parties was from the contract. And then finally, it has to be legal, it has to have a legal subject matter. And I've seen startups get in trouble over each and all of these components over the years. So let's start with, again, back to the basic concepts. One of the things that comes up right away is the idea of a writing behind a contract. And it's important to note that generally, you don't have to have a writing to have an enforceable contract. There are exceptions. Anything to do with real estate typically has to be in writing. Anything to do with contracts that can't be performed within a year. We have this thing called the Uniform Commercial Code in all 50 states that I'm going to talk about soon, or some variation of it. that I'm going to talk about that requires certain contracts for sales of goods, not services, but goods to be in writing. And here's an odd one, a guarantee to pay the debt of somebody else generally has to be in writing. Now, so even when a contract must be in writing, it's surprising how little it takes to satisfy that requirement. That could be an email, that could be a text message. There's cases on this. It could be a letter, it could be a memo, and importantly, current law now allows electronic signatures to be sufficient to constitute a signature on a written contract. Now, I'm going to get into when a writing is not required, so let me just put a pin on that. But the reason I mention this is because I have seen fortunes made and lost on the back of a cocktail napkin, and I am not making that up. People walking them on. In fact, the one and only jury trial I ever tried in my life before I became a corporate lawyer was exactly that. It was some notes scribbled on the back of an envelope in that case. And the person who made the promise reached this contract and said, there's no contract. We don't have a big fancy document with, with stamps and seals and notarizations and all of this. But my client had this little scrap of paper, with some notes on it. And we went into court and we sued on that and we won. It takes very little to satisfy this writing requirement. When it's even required, because most of the time the writing is just there as a proof issue. It's just evidence. It's just to show the court what was intended, because generally you don't need it. Consideration. I want to pause on this because this is maybe the most difficult concept in contract law for people to understand, and it comes up and bites people later on. Just because you and I agree to something doesn't mean a court's going to enforce it. If I say, hey, Bob, I'm going to take you to lunch tomorrow. Well, he's not going to be able to sue me and enforce that unless he can find some bargain for exchange, right? That's the consideration component. It is the bargain for exchange. People confuse that with value, but it doesn't mean value. In law school, we all learned the quote from a famous judge that said, a peppercorn can be consideration. I don't know what a peppercorn is, but I think it's something that's worth very little. Okay, as long as that's what you're bargaining for, right? So Bob, will tell you what, if you give me $10 today, I'll take you to lunch tomorrow. Now we've got consideration, and it doesn't even have to be $10. Bob, give me $1 today. I'll take you to lunch tomorrow because I really need $1 because I got to pay, for my parking or whatever. So as long as it's bargained for. Now, a couple of concepts here. There's a saying in the law, past consideration is not consideration, because we sometimes see that. Bob has done something for me already, and I say, gee, I'm so grateful for that I promise to buy you lunch tomorrow. And the consideration to support that is that thing you did for me yesterday. Well, that doesn't work, because that is no longer a bargain for exchange. It's not something that he was obligated to give me. He was entitled to that already. Let me, and that's where I say a promise to do something you're already obligated to do. Now, why am I pausing so much on this? It's because I'll tell you how it comes up most often, and that's in releases, where we see somebody is, and usually in the employment context. And you probably wondered about this if you've ever been through a severance agreement where the employer always pays like a couple weeks of pay to support a release, we call it. Doesn't have to be 2 weeks, could be anything, as long as that's what's bargained for, to support the release. And every once in a while, you'll see an agreement that says, oh, we're separating, I've been paid everything I'm entitled to, I've gotten all the benefits, and oh yeah, I agree to release you. And that's always suspect, because the litigation attorneys will look at that and say, why do you think that release is enforceable? What's the consideration to support the release? And the answer should be, if you give us this release, we will give you 2 months severance. So that's the most common example of that. And these days, when you can just go online and download forms and draft all these contracts yourself, you can get into all sorts of trouble. And that's probably the one thing that is most easy to mess up, because it is sort of counterintuitive if you think about it. Now, for every good rule, there's got to be a million exceptions, right? So the exceptions to consideration are, I guess we'd call them substitutes as opposed to consideration exceptions. One is, let's say we have detrimental reliance. Bob, I promised to take you to lunch tomorrow. So Bob, in reliance on that promise, he goes and cancels his lunch with somebody else. Okay, so he's relied on my promise. That is a substitute. He no longer has to prove consideration to sue me to enforce that promise and get damages if I breach. Another substitute, what they call unjust enrichment. Bob, I promised to take you to lunch tomorrow. And based on that, Bob does a lot of, good things for me, and I am enriched by that. So if I don't take him to lunch, well, that's pretty unjust. Very similar to this concept is promissory estoppel. If Bob acts, and very similar to detrimental reliance, if he can act on my promise, he can say, look, you are estopped. I love words in law, they're also archaic. You are estopped from denying this contract because I've acted on it. The UCC, which we're going to talk about more in a little bit, Uniform Commercial Code, which deals with sales of goods, has all sorts of other modifications to this consideration rule, just so that commerce can happen more smoothly among merchants. And then performance, of course, if one party performs, even if there's not consideration, that could be enough to satisfy that prong. Now, of course, there's a million statutory exceptions that you always have to consider. There's consumer protection statutes that might remove the requirement for consideration when you're dealing with consumers. In family law, we'll oftentimes see people, instead of consideration, it'll be something that doesn't really sound like consideration. So there are places that you have to look in the statutes where you don't need this concept of consideration to support a promise. Meeting of the minds. And this is the napkin, note on a napkin idea I was telling you about. And again, this will surprise people how little it takes to actually have a meeting of the minds. It really is just that the parties understand and agree to the essential terms of a contract. Would a reasonable person believe that the parties agreed to the same deal? Now, there's always tons of litigation around this, is when, yes, we have a deal, but we didn't get every single term of the contract. So we go into the court and we ask the court to supply the term. And different courts have different views on this. Some are a little more liberal than others in terms of whether they're going to supply a term or not. So for example, let's suppose, and this is how I learned it back in the Midwest where I'm from in North Dakota, the example was, Bob, I agreed to sell you my cow. And Bob says, I agree to buy it. Now we got a contract, but we didn't agree on a price. All right, is a court going to supply that term? Maybe, maybe not. A court might say that term is so fundamental to the contract that we can't supply it. But you know what? You'll find other courts that'll say, you know what? We can figure out what a fair price is. We will enforce that agreement. So you can see how this gets a little fuzzy, and there might be a little bit of forum shopping. These terms can be implied by fact. They're just so obvious. Like when you go into a supermarket and you buy something, and you don't say anything to the person behind the counter, but it's just so obvious that you agree to pay for the product that you're taking and walking out with that they just go without saying. Statutes can imply terms like this reasonable price example I gave you under certain statutes. By industry, by custom, industry norms can fill in. We just always do it that way. You should just expect that was it. By the way, I've had that argument used. I've used it and I've had it used against me on vesting terms. When parties go out and do it themselves and sell stock and they don't put a vesting restriction in, and they'll argue, well, no, you should just have expected we meant that, because vesting always applies. I don't think it's a great argument, by the way, but I've heard it used. And then under the Uniform Commercial Code, and this is one of those areas where we just have to, grease the skids a little bit from common law contract law so that merchants can do business and say, look, we're not going to invalidate a contract because you forgot to say the delivery date or even the price. We'll just supply reasonable defaults. By the way, whenever you're involved in a sales of goods context, all of these rules, you have to go consult the Uniform Commercial Code on this because statute has supplanted a lot of this. I do want to pause at this point again and bring this back to startup land. Where does this come up? Because this is all fun to think about, and a lot of good legal philosophy here, but how does this apply to me, the startup? Well, the first place is in term sheets, or what we call memoranda of understandings, MOUs or MUIs. And sometimes that's just in emails back and forth between parties. And the number one issue is, gee, is this binding or non-binding, right? Because you're going to get a term sheet at some point, and you're going to sign that term sheet possibly. And the term sheet's going to be pretty skimpy. It's not going to have near enough direction in it for you to execute on the transaction. That will require additional, what we call definitive documents. And that's a later big, thick agreement that goes into all the details. And if you've been through a legal transaction, you know just how outrageously detailed these can be. It gets everything but who's going to lick the stamps that go on the letter that give the notices. They can get pretty detailed. They don't have to be that detailed to be binding, but the more direction, the better in contracts. So anyway, term sheets. So is it binding or non-binding? Well, let me tell you, if it does not say it's non-binding, it is probably binding. So that's why almost every term sheet, because it doesn't have enough direction, will almost always say this term sheet is non-binding. But let me tell you the trick that's in here is that even though it says it's non-binding, if you're in a state like California, it might not be non-binding. There might be provisions of it that are binding. In particular, California imposes an obligation of good faith and fair dealing. So it might bind, just the fact that you signed a term sheet might require you to negotiate in good faith to execute that term sheet. Well, so you don't have a bad faith claim. How do you know that you've satisfied that standard? You really don't, right? You could go on for a long time just trying to get to a deal, and you can't get there because you're arguing over where the commas go in the agreement. And you want to walk away because you're so disgusted with the process after all this negotiation, but you're afraid to because, gee, what if somebody says I was negotiating in bad faith? Well, the way around that is just to put a drop dead termination date in your term sheets or MOUs or any agreements that you have. And that way you don't even get into that issue. We didn't come to an agreement within 30 days, our term sheet said we had to, or it was terminated by its terms, therefore we're all done. Where this comes up most often is in what we call agreements to agree. And you'll see that a lot. In fact, that's what a term sheet is. In effect, it is an agreement to agree. And will courts enforce them? It depends. It depends if there's enough direction in the term sheet and if that's what the parties intended to happen. By the way, I want to pause. One other thing on this is a lot of times you'll see term sheets exchanged, you'll see emails, you'll see people use agreement language and then change their mind, or maybe they can't they can't come to terms, and they'll say the deal's off. And somebody else will say, oh no, we've got this verbal agreement. Remember my first slide, an agreement doesn't have to be in writing typically. We've got a verbal agreement, I've got all this evidence. And the counter to that is that, no, we always intended that the agreement of the parties would be in the definitive agreements, that big extensive document that we have yet to execute. And because we couldn't get to terms on that, we have no agreement. And courts will uphold that position because that's typically what parties mean, right? I think everybody on this call, when you sign a term sheet, you just expect you don't have a deal until you sign the final agreement. So that is the position that is usually taken. Performance and excuse. So performance just means that you're going to do what you promised to do under your contract, right? I promised to take Bob to lunch and Bob promised to do something for me in exchange. That's our mutual performance. Now, there are areas where that performance is excused. And one is impossibility, or if there's an unforeseen event that makes it impossible to fulfill that contract, then that will excuse my performance. I promised to take Bob to lunch at, Bob, what's a restaurant that's recently closed? I think a lot of them went out during COVID.
Recently closed? Here at Lake Almar. God, recently.
I promised to take All right. I promised to take Bob to lunch at the fanciest restaurant in town, and once you know, then they burn down. So now it's impossible. So he can't sue me for not taking him to lunch there. All right. Frustration of purpose. The contract's purpose is destroyed by unexpected events. We saw a lot of that during COVID, right? I'm going to talk more about that in a minute, though. So let's just put a pin on that.
Roger,
for a
I think it's implied because of the seminar, you're gonna take me to lunch.
Yeah, well,
For
good.
for my services here today, yeah, good.
Well, okay, I'm gonna find me an excuse then. Performance is possible, but it becomes very impractical. So I think the famous case is somebody rented a room on a busy street so they could watch the Queen go by during the parade, but then she changed her route. So my purpose was frustrated, so I was not obligated to rent the room. Force majeure, we'll talk more about that. You heard a lot about that during COVID, right? A lot of tenants said, look, I have a force majeure clause. It means that my performance is excused because of natural disasters, and the COVID shutdowns were natural disasters, so I don't have to pay your rent. We had a lot of litigation over that. And it all came down to what was in the contract, by the way. How was your force majeure clause drafted? And the interesting thing about that is I've been putting force majeure clauses in contracts for almost 40 years. Never, ever, ever did it ever come up. Ever. Never. Not once until COVID came along. And then it was the most important clause in the contract. So there you go. Statutes limitations, and this is the idea that the statute that our legislatures enact statutes that say, look, you have to enforce a contract within a certain amount of time after a default, otherwise you are forever barred. And we'll talk more about that. And then finally, just other defenses that render contracts void. For example, lack of capacity, lack of consideration, no meeting of the minds, etc. Okay, well, here we go. Speak of which, defenses to enforcement. So capacity is just the idea that the parties are legally able to contract. So for example, there's some contracts that a minor is not able to agree to. There are contracts minors can agree to. All right, you have to look at the statutes. But an insane person, for example, somebody, so you have to have what they call legal capacity. The law will protect people that don't have that kind of capacity. It has to be legal. I mean, that seems obvious, doesn't it? Well, how does that come up in startup land? I see companies all the time forming around trying to disrupt a regulated business. So for example, let's suppose that, so I'm in a regulated industry. In order to practice law, you have to have a license. Let's suppose creates a startup and they enter into a contract that they're going to provide legal services through an online platform. Somebody might challenge any of those transactions and say, well, that's not legal. I haven't seen that in law. There's plenty of online platforms like AI that do that. I have seen that in real estate. I've seen real estate online automated brokerage contracts basically fail for lack of legality. Failure consideration, we've talked a lot about. Duress. This is an interesting one because it's not maybe as broad as you might think, right? If somebody puts a gun to your head and says, sign, all right, you can challenge that contract that you just signed under duress. But you know what? There's duress in every contract. If you think about it, there's this concept of economic duress. I have to sign this contract or I'm not going to get paid. And if I don't get paid, I won't be able to pay my rent and I'll get evicted. Well, is that duress? Probably does not meet the legal standard for duress. So this is one that I've seen people kind of argue around the edges on that and dance on the head of the pin. But keep in mind, duress has to really be, you really have no choice. Undue influence is sort of a very similar idea. Again, the law just says it's really not fair to enforce this contract because of the way you were influenced in doing it. Usually if there's some sort of relationship between the parties, you'll see that like a parent and like a child and a very elderly parent, something like that. You see this in wills, trusts and wills more often. Fraud or misrepresentation, you can always assume that anything that you've agreed to by fraud is going to get tossed out. Mistake we'll talk about because that's subtle. Some mistakes, yes, other mistakes, no. You should have known, and it's a mistake only on your part. For example, if I say, well, we'll talk about it in a second. Unconscionability. This is something that courts have provided. If it's very rare, but sometimes a contract is just so outrageously unfair that a court will say, you know what, we're just not going to enforce that. Yeah, you agreed to it, but it's just so outrageously unfair. And usually this comes up in a consumer context, hardly ever in a business context, because businessmen are assumed to be able to protect themselves. But consumers who just sign a lot of stuff and don't read it and have no bargaining position anyway, those contracts get tossed out for unconscionability often. And a statute of frauds is the idea that some contracts must be in writing. Okay, but we're spending a lot of time on basics. Don't worry, we're going to get into specifics in a minute. Breach and remedies. What happens if somebody breaches a contract? What does the aggrieved party entitled to recover, and what does the dirty breacher have to pay? So number one, money damages. And the case that we all heard about in law school was about the person who, I can't remember now, it was a medical procedure, and they were promised a Hedy Lamarr nose, I think it was plastic surgery, and they ended up with, well, I don't want to use any names. They ended up with something that was not a Hedy Lamarr nose, right? So what are the damages for that? Well, it is, honestly, the measure is the difference between what you were promised and what you what you received. Those are compensatory damages. Consequential damages, what that means is all the damages that just naturally flow from the breach. And that can be a big number. I've seen people go way out on a limb like this. For example, the product that well, let me give you an example. I'll be careful here, but many, many years ago, I had a client that entered into a contract with one of the largest distributors of electronics in the world. And I reviewed this contract and I said, you know, we should have a cap or just eliminate consequential damages altogether, because this company's about to buy your product. And if something goes wrong, their damages are going to be lost profits from not being able to use your gadget in their product. And that could be a big number. And my client said, yes, I understand that risk, but we have to take it because this deal is just so sweet. So no, we're not going to change their contract at all. So we had no limitation on consequential damages. And remember, consequential damages, all the damages that naturally flow from a breach. We were selling a gadget that was going to be incorporated in their widget, which they were going to sell to the public. Well, almost immediately after they announced, somebody sued my client for infringement. We were no longer, and they got an injunction, we were no longer able to sell that gadget. Because of that, the company that was buying the gadget could not incorporate it into their widget, and they could not sell their widget. And they came back with a claim for consequential damages of more than $1 billion. And my company went right straight to bankruptcy court. And my client did. So you always want to limit. Consequential damages can be large. You want to limit those. That's what that means. Liquidated damages is the idea that we agree up front. Look, if we breach this contract, we will pay you X dollars, and you agree that's a fair number. That really approximates how much damage we could actually do to you. Those are great clauses because everybody knows what the cost is going to be. And nominal damages are really usually, it's just, look, you breached the contract, but so what, right? And so I promised to take Bob to lunch, and he paid me for that promise, or he gave me some consideration, and then I didn't do it, so I breached it, but so what? He can still sue me and get $1 worth of damages, because that's what my company is worth for 1 hour, apparently. And usually you would only do that as a hook to hang a claim for punitive damages or attorney's fees or something else on top of it. Sometimes money damages aren't enough. I mean, they just don't quite do it, right? For example, in confidential information agreements, it's hard for us, or maybe a copyright infringement, for example, or trademark infringement. it doesn't quite do it to say you're going to pay me X dollars, because I can't really prove that I've had a lot of money damages, but I still don't want you disclosing, my confidential information all over the place. So we go into court and we ask for an injunction, right? And an injunction basically prohibits somebody from doing something. Specific performance is the flip side of that, where the court will order someone to do something they promised to do. I paid you, and for your car, you didn't deliver the car. I don't want damages for you not giving me the car because I really like that car. Or maybe it's a painting. So the court, when money damages aren't adequate, like if you have a painting that's unique, the court will order a transfer to me of the painting that I paid for. That's specific performance. Rescission, you breached, therefore I am excused from performance. I can walk away from the deal. Just keep rescission, we use a lot. Just two things about rescission. Number one, in order to have a good rescission, you basically have to return everything that you've received, right? So you've partially paid me for the product, but not everything. I rescind and I give you back what you've paid me. That's a rescission. The second thing that you might want to keep in mind, and pardon me, it's an occupational hazard. I got to talk about tax every time I can. People really have trouble with this, but I promise you, it is the law that a rescission, if it straddles a year, is going to be treated not as a just cancellation of the original agreement. It's two separate transactions. And that means you could have tax on both sides of that transaction. So you have to be really careful about tax whenever you have a rescission. Restitution, you just make somebody whole by returning what they've given you. Or if there's a breach, maybe you just say, look, you've breached, I'm hereby terminating this contract, and that might be good enough. Okay, let's get down to some basic clauses and some commercial contracts. Everything that you might expect. These are kind of the basic clauses that go into everything. Remember what I said, we got to have enough detail that a court can enforce something. They know what to enforce. Well, obviously we should identify the parties. Secondly, we should have a description of whatever it is that is being bought or sold. We should have the terms of delivery and performance, the price and payment terms. I'm going to go through each one of these in particular, so I won't reiterate them now, but let me just pause to say that there comes a point where the law meets practice and practicality. And these are the clauses that we want because we want a good enforceable contract. But not only do we want a contract just to compel people to do things and put in writing something that courts will enforce, but we also want a contract so that we can give direction to parties and explain to them what's about to happen and how it's going to happen. And I'll show you some examples as we get into this, but you'll find that different lawyers will draft contracts different ways. But my practice is to go beyond just what is legally required to have something enforceable and say, not only are we doing this as this legalistic enforcement mechanism, we're also doing this because we want a manual for the course of conduct that the parties are going to follow going forward. And I think that is a good practice. We'd like to outline what the parties are going to do, what their rights and responsibilities are, what they're going to receive, what they can expect, and the more clearly we get on it, the more misunderstandings we're going to prevent. Now, there is this principle of relative ambiguity that is worth mentioning here. And that is the idea that no matter how much detail you put into an agreement and how much you try to hardwire what's about to happen, there's going to be an ambiguity someplace. You will never eliminate 100% of all ambiguities that could arise. And that's just something you might as well accept up front. And, I remember I learned years ago that the philosopher Wittgenstein came up with a new language of philosophy that would have no ambiguity, and he finally gave up on it because it is just not possible. It's the same in contract law. You will always have something that people are going to misinterpret, and you don't know what it's going to be because you can't anticipate every possible conceivable scenario that comes up. So we just do the best we can so we can prevent any misunderstandings for what might happen in the future. But if we miss a scenario, don't blame your lawyer because we can't possibly account for all of them. Some examples that seem pretty obvious. Let's get into the details. Oh, reps and warranties. Most contracts will have a set of factual assurances and promises right? So you're buying my company, we'll say, I'm gonna give you reps and warranties that I own the shares of stock that I'm selling you. I'm gonna give you a rep or a warranty that there's no liens against it, so no one else is gonna chase you if you buy this stock, that there's no liabilities or claims here that we haven't told you about, that my IP is clean, on and on and on. Those are reps and warranties. They're basically just factual assurances and promises upon the basis upon which the contract is made. And by the way, that protects everybody because then we have less ambiguity. So now we can look exactly and point to the contract and say, this is exactly what I promised you and nothing more. And if you're a buyer in that scenario, you'll say, hey, this is exactly what you promised me and you did or did not deliver. And if it turns out to be false, it's a breach of the contract, and slide before as to what you can do when a contract's breached. Now, again, like I say, sometimes a contract is this legalistic mechanism for telling a court what to do, but also it's just a user manual for how the parties are going to act. In this case, it's a risk allocation mechanism. And this is another place where it sounds a little odd, but you'll sometimes see parties sign up to reps that they're not entirely positively sure about. Well, how can that be? Because are you signing up to an agreement that you might breach? And really, it's not so much that, it's really, we're just allocating risk. So let me give you an example. If I represent to you that my intellectual property that I'm selling you doesn't infringe on anybody else's, I typically would not make quite that broad a rep, but let's say I do. Well, what happens if it turns out that it does infringe? Yeah, it's a breach of the contract and all the things that the contract says will happen, but mostly it's just allocating the risk of that happening back to me. Conversely, if we have a contract where I say, look, I will represent to you that nobody's given me notice of any infringement of my IP, but that's all I can tell you. Well, all I'm doing is I'm shifting the risk of infringement now to the buyer, right? Because if I in fact have not gotten any notice, but it turns out that the IP is infringing, well, now that's the buyer's risk. And that's how we typically think about it in the commercial context. Here's a handful of reps. I'm going to distribute the slides later. You can go through these in detail if you'd like, but these are very kind of standard sort of reps you'll see in most contracts. Similarly, the buyer is going to make representations that their money's green, right? That they have the right to enter into the agreement. If it's a deferred payment, that they're not insolvent, that they're able to make their payments, and importantly, that they're not going to get you in trouble by signing this contract. You're not violating any other agreements. Here's a pretty standard indemnification clause. You'll see, this is very much simplified and pared down, but it gives you an idea. And again, this is where I get back to saying, you wouldn't really need this at all. The court, by the way, there's hardly a dispute that a court can't resolve, right? So if there is a breach and you have nothing like this, the court can decide if there's a breach. The court can decide, how much the damages are. The court can decide what you have to pay, etc. But that's not really satisfactory to contracting parties. Instead, we'll just specify all that by contract. So if there is a breach, we're going to indemnify you, right? And our indemnification is going to be for these specific things and nothing else, right? It's a risk allocation component. And not only that, we'll typically put all sorts of limits around the indemnification. It's not going to go more than this amount. We're not going to cover these types of damages. Remember, consequential damages. It's not going to be, you're not going to be entitled to any damages until you exceed a certain amount. You're not going to be entitled to damages unless this breach occurs within a certain time frame. Stuff like that. So we always, I know everybody just freaks out every time they see one of my 30, 40, 50 page agreements when they had a 2-page term sheet. But this is why, we really want to specify and hardwire this as much as possible, because yes, a court can decide all this for you, but you might not like how that gets decided. And enough said. Warranties and disclaimers. So let's say we have a contract for the sale of goods. You'll almost always see a very specific clause relating to what is being warranted. rather than just the law will supply this, by the way. The law will absolutely supply this if you don't say anything, but the parties hardly ever want that, especially the seller. Usually they want to disclaim all these warranties that the law will otherwise provide. So you'll see this disclaimer language in a lot of contracts, and you might see the words as is. As is, that's a term of art, and it means exactly what it sounds like. It means you're taking it as is with all its faults. So don't come back and sue me if it turns out that this product is not merchantable, meaning you can't sell it. It's not fit for its purpose, or it's got bad quality, etc. Confidentiality, what I want, we did quite a bit of talking about this in previous sessions, so I won't belabor it again. I will say that a lot of times contracts will have confidentiality built right into the contract, into the main agreement. And now's a good time to just pause and say, when would you just have a separate confidentiality agreement? Because they can be pretty detailed. Or when would you just build it into your main agreement? We have a contract for the sale of goods, or maybe I'm appointing you a distributor, or maybe you're an independent contractor. When do we build that into the contract, and when do we carve it out? And not just confidentiality, any other clause. And my kind of rule of thumb is that if this is a super important term of your agreement, you build it into the main agreement. If it's not, if it's sort of ancillary, we keep it out of the main agreement. Why is that? Because if you get into a dispute over that thing, do you want to drag the whole contract into court? Or do you want to just be able to argue over that one particular clause? So confidentiality is the only one that comes to mind, but we might just carve that out and say, look, if somebody breaches confidentiality, I don't want the whole agreement in court. I want to just go into court over that one separate confidentiality agreement. So it's a little bit of posturing. Termination, every contract will typically tell you what the term is. If it's executory, meaning that there are duties to be performed in the future. Maybe there'll be renewals that'll be in the contract. Can it be terminated? And sometimes for convenience, meaning that either party can terminate whether they have a good reason to or not, and sometimes for cause. And usually it's a notice difference. You can terminate for convenience, but give me some notice so I know it's coming. But you can terminate for cause and a lot less notice, because if it's for cause, we need, you want to get out of it as soon as possible. Notice and opportunity to cure. Sometimes it's like, look, don't sneak up on me and just terminate it because I had some, minor default. Let me know what I did wrong and give me an opportunity to fix it. And if I don't fix it, then you can terminate. And then finally, change of control. And related to that, all sorts of other things that are sort of like change of control. And this is really important because a lot of times, a company will have lots and lots of contracts, vendors, suppliers, contractors, on and on and on. And when that company gets sold, well, that's a change of control of the company. We have to go look at each one of those contracts and find out if there's a change of ownership or change of control clause. And we have to look at the specific language because it may or may not make that contract assignable. And it may say, look, if you sell your company, you have to give us notice. And if you don't do it, if you don't get our consent, that's a breach of the contract. We can terminate the contract and then we can sue you. So we have to look at that clause in every contract. And there's no easy way around this because they could all be different. And they usually are. You've got clauses that range from everything like, if you change the name of your company, you got to get our permission first. And if you don't, it's a breach. All the way down to this contract's freely, do whatever you want. It's freely assignable. So you just really have to examine all of them. Contracts will often define default. Now, payment default's pretty easy to see if it's a contract that requires payment. But, there's this concept of non-economic breaches, right? Suppose the quality's, maybe the quality's not what it should be, but more often it's something like there's a covenant that somebody breached. You're going to give us financial statements. You're going to hit a certain, especially in bank lending, financing contracts, you're going to hit certain financial metrics. If you don't, you've breached it, even though there's no payments that you didn't make, etc. Change of control we talked about. We could do a whole hour on a clause that says you're in default under bankruptcy. That's all bankruptcy law. I just want to mention that is a whole body of law by itself. So you can't assume that that's going to work out the way you think it might without consulting bankruptcy counsel. And then all sorts of other covenants, usually they're financial. Okay, I promised I'd come back to force majeure. We saw this come up in COVID. Tenants were using this a lot. This is a standard force majeure clause. I think people pay a lot more attention to this now than they did 5 years ago or 6 years ago. So there it is. Performance is subject to acts of gods, meaning that it's excusable if one of these things happens that makes it impossible for us to perform. By the way, I live in south of San Francisco. Do you think an earthquake would be a force majeure? Do you think that would trigger a clause? Let's say that I'm prevented from performing my contract because we had an earthquake and I wasn't able to perform. Probably not. I mean, that is not so unforeseen that we call it, unless you specifically have a force majeure clause that basically says that that an earthquake is an act of God. So we get into those sorts of issues. All right, dispute resolution. Suppose we do have somebody says, hey, you breached, and somebody else says, no, I didn't. That was an act of God or whatever. How do we resolve that dispute? Well, a well-drafted contract is going to say, first of all, what law is going to apply. You might not want California law to apply. You might want it to apply. And then secondly, where the dispute is going to be heard. And those are super important. Why is that? Because, trust me, you want to be in your home court when you have a dispute, because it is hugely disruptive to have to travel across the country or to another country to have to argue a case. And it might make the difference between bringing the suit and not bringing the suit. So this is something that is heavily and hotly negotiated in a lot of agreements. You might decide, you know what, I saw what the California court did in that O.J. Simpson case 30 years ago, and I've never trusted them since. I don't want to be in court. I would rather have an arbitrator. You can agree to that. You can have a clause that says, look, we're going to go in front of a private arbitrator. And lawyers have very strong opinions on whether they like arbitration or don't. I don't really have a strong opinion on it. I don't do enough of it to say. I will say there is a perception that arbitrators split the baby, that arbitrators, because their judgments are not appealable other than, abuse of discretion, et cetera, that they have a tendency, or they could ignore the law if they want to. Yes, but I honestly don't think that happens that often. I think arbitrators, especially if you get reputable organizations, are going to do their best to apply the law and honor the parties' expectations. And then finally, some contracts will require you to mediate instead of arbitrate. And I have a whole podcast on the difference. And I have another one coming up on the difference. So you should go watch that if you'd like to. But arbitration, the decision is forced upon you by your own private judge. Mediation, you sit in a room and the judge might twist your arm and pressure you to agree, but you're going to agree to whatever the resolution is. I just want to mention export control. Because all of our contracts now, if it's international, I'm not going to go through this whole slide. You can read it at your leisure. Just understand that if you're shipping IP outside this country, the United States, you're going to have to worry about the regulations. And IP is broadly defined. Sending an email can trigger export control rules. So be careful about that. So we oftentimes will have a clause in a contract that will just, clarify. And this is another one, that it's really good to put in a contract just as a reminder to everybody, that, look, we all agree we're going to comply with these export control rules. And if you don't, you're going to have to answer to me. UCC, Uniform Commercial Code, it governs contracts for the sale of goods. Let's talk about a few of those terms. They have standardized shipping terms under the UCC. Those are trade terms. So you've heard of FOB or FAS. UCC, instead of having to just write out all of the duties and obligations of merchants when they, for example, who has to insure the product in transit, who pays for it if it gets lost, who pays for it if the boat sinks, stuff like that. Instead of having to write that all out in agreement, we can just use these shipping terms. Who has to pay the cost of hauling it, from the ship to the, to the warehouse, et cetera. we're running out of time, so I'm not going to spend a lot of time. So I'm just going to say that there are terms of art as to what these terms mean. You use these terms, you don't have to have 200 words explaining them. Similarly, we've got something called Incoterms, which is used in international contracts. And typically the contract will just say, we are going to apply Incoterms. And they're like UCC terms, only they're much more expansive. I wrote a whole chapter for a book on Incoterms. If anybody, needs something to help them go to sleep some night. But we've got lots of terms that go into great detail. Use these terms and they'll tell you who bears the risk when we have a transfer of goods from one country to another. Just want to pause on a couple other types of contracts that you're going to run into. Real estate leases, really their own world unto themselves. You got to get a real estate lawyer if you're looking at a real estate lease, or at least somebody who has done these before, because these are so market driven and there are so many gotchas that it's really important to work with somebody who's been through all of these issues. These are all clauses that are very unique: security deposits, permitted uses, who's going to pay for maintenance and repairs, what about insurance, etc. Similarly with bank debt agreements, again, these are so market driven and there's so many very specific clauses to the lending industry that they're worth calling out as a separate area of practice on their own. What I will tell you is, like I say, it's so easy to go out and do it yourself, but I've had it happen more than once in my career where one of my clients has come to me and they said, I signed this agreement with my bank, standard agreement, didn't think it was a big deal. I didn't have any lawyer review it. So of course I didn't read it. And now my bank just told me that, gee, I have to pay default interest because I was late on a payment a year ago. Or I had one case where the company said I changed the name of the company. I didn't tell the bank. And now they say I owe them 18 months of default interest. And what that is, that's a very high rate of interest that goes into effect for as long as you are in default under agreement. And some of these agreements will say they don't even have to tell you you're in default. And they'll do what we call sandbagging. They'll just sit there and let the numbers accrue. And in fact, I had one case where the default interest was over $1 million. Before the party that was in default, and the party that was in default didn't even know they were in default. And by the time they found out about it, $1 million of default interest. So again, this really has to be left to the experts. And what you'll see most often, independent contractor agreements, all the usual terms. What we usually argue about most in these is just IP, like who owns the tools. And the compromise is, look, if I'm building it for you, you have that, but I get a right to use it if I need it, for my next gig. And the tools that I use to make your thing, I'm not transferring those to you, those belong to me. All that should be specified in the agreement. Reseller agreements, that's where a supplier just authorizes someone to resell their products. It's could be exclusive and oftentimes is. And it's where the reseller deals directly with the supplier, oftentimes a manufacturer. Very similar to that, but different, is a distributor agreement or distribution agreement, where the distributor has a right to sell products in a defined term, in a defined territory. Agency agreements, similarly, very similar. Somebody is out selling on behalf of someone else. I've just outlined some of the essential terms. And then finally, I want to talk about click graph, because this is the idea that you can agree to. In fact, everybody on this webinar has probably many times, in their lifetime, gone onto a website and agreed to a bunch of terms they've never even read because they clicked, I agree or I accept. And they're used very often in licenses and apps on websites. And the question comes up, because I've had it happen. It's like, wait a minute, I'm stuck with that. I've had clients come to me, well, I agreed to that. Can they enforce that? And what the courts will say in that case is that, yes, if you clearly had notice and you click that button, and if it's not just totally unreasonable, then yeah, you're stuck with it. Now, every once in a while, a click wrap agreement might go so far, especially for consumers, because they can say that's unconscionable. Remember unconscionability. But for the most part, yes, click wrap is enforceable as much as you might not like it. Common issues that come up in all contracts. Whoops, let me back up. Sometimes the terms are too vague or ambiguous. Usually have payment disputes, performance issues. You'll sometimes hear misrepresentation. I never would have agreed to that if I'd known this. You'll see that a lot. Mistakes. Maybe unfair terms, or most often parties just don't follow the contract, right? And then they'll say, well, we had a contract, we just verbally, amended it. Now, most well-drafted contracts will have what they call will have a parole evidence. Well, for two things. They'll have an integration clause that says it doesn't matter what we talked about before, whatever it says in this written document governs going forward. And then secondly, if somebody tries to vary it going forward, we've got what we call the parole evidence rule, which prohibits verbal variation of a written contract. Some current issues that come up, like I say, IP is oftentimes a really big one that comes up into a lot of contracts. Anybody in this area who deals with IP, I don't know about this Stanford University case at the bottom, where it's kind of a complicated case, but basically the takeaway is that I agree to assign is much different than I hereby assign. Because somebody entered into an agreement that said, I agree to assign my IP. Then they entered into an agreement later that says, I hereby assign my IP. And the court said, well, that first, and then the party came along and said, look, we got the IP first. He didn't have it to assign because he got this agreement that says, I agree to assign. And the court said, well, yeah, agree to assign is not the same as assign. So no, he agreed to do it, but he didn't do it. So that's how important the words can be. Just two little words, right, in a contract made all the difference in the world. Data comes up all the time now. Who owns it? Who gets the right to use it? Are you going to keep it confidential? You're going to return it? You're going to destroy it? I do a lot of work with agriculture technology, and this is one of the hot button issues in every agreement. Who gets the farm data? In fact, I've got full hours on this on my YouTube channel. Privacy and security, it's of course a big deal now in a lot of contracts. Just complying with those regulations, we could do an hour on that. I guess the last thing I think, I hope this is the last slide, is smart contracts, which is something you may have heard quite a lot about. And, I like to say, well, it's not very smart. And it's not really a contract, but it basically is just a self-executing digital agreement. When Bob goes down to that soda machine in his lobby and buys a Coca-Cola after this session, he's going to enter into a smart contract with that machine, right? Because it's all code and it just happens automatically, autonomous, immutable. And lately, of course, now smart contracts are on the blockchain. And I don't want to even open that can of worms other than to say that it's something you ought to be familiar with. And yes, you can have an agreement that is all digital and fully automated. And that's what we're seeing more and more these days. Code is law is how they say it in blockchain language. And what do you know? We are at the end and we are at an hour. I'm Roger Royce. I'm a partner with Haynes Boone in Palo Alto. This has been Legal Foundations Contracts. I'm the author of 2 books, Dead on Arrival, How to Avoid the Legal Mistakes That Could Kill Your Startup, and more recently, 10,000 Startups, Legal Strategies for Startup Success. We will be back next month with our next session, which is going to be, you're not going to want to miss it, on financings, right? Financings, the law of financings, angel, venture, private equity, private offices, etc. So thank you all for joining. And with that, I am going to stop the share.
Very good. Thank you, Roger. That was excellent.